Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I'm your host, Uncivil Law, a licensed attorney in Texas, Virginia, and before the U.S. Supreme Court, and I hope you're having a great day. For today's coverage, we turn our attention once again to the Take Care of Maya trial. You'll remember Maya Kowalski, who was treated and somewhat mistreated by Johns Hopkins All Children's Hospital, although Johns Hopkins All Children's Hospital doesn't quite see it that way. Johns Hopkins All Children's Hospital is of the opinion that Maya got excellent care, life-saving care, and that she is alive only because of the wonderful care that Maya received at their caring hands. However, a jury, having heard the case, is somewhat of a different opinion that more aligns with Maya's, in that Johns Hopkins did a bad, to the tune of about $200 million plus about $50 million again in punitive damages. Well, we're still somewhat at the trial phase as we're trying to wrap this up towards appeal, and we have new and exciting motions relating to this. Namely, we have a motion for bar referrals and also a motion for damages in relation to attorney's fees. Very exciting. So, I believe that Johns Hopkins All Children's Hospital's attorneys at some points somewhat violate the rules of ethics. Not exclusively, but perhaps most notably when I was paying attention, when they drug juror number 1 all over the coals for absolutely no reason, which Florida has specific rules against not doing that thing. And they did the thing. A lot, including the secret Nazi communications. Yeah, so we might want to get some sort of bar referral going on. So we will begin there. We begin with the plaintiff's supplemental motion for sanctions and consideration of bar reversal for the deliberate misrepresentations and elicitation of false testimony and other conduct. Yeah, that sounds very, very plausible to me. Johns Hopkins seemed to somewhat at times potentially push the boundaries of attorneys' ethics in a way, incidentally, that makes attorneys look bad. You're not supposed to do this because it makes the profession look bad, and I don't like that very much as a professional. I feel professionally insulted by Johns Hopkins contacts because it makes me look bad. So please stop doing that. That'd be great. Let us read this motion and see what Maya has to say on the question of, did Johns Hopkins lawyers do it bad? Are Johns Hopkins lawyers of the same cloth as the All Children's Hospital? Johns Hopkins All Children's Hospital did it bad. Did the lawyers also do it bad? Let's read on. The plaintiffs, by and through their counsel, hereby submit this motion and move the court to consider and make such referrals to the Florida Bar of Defense Counsel for Johns Hopkins All Children's Hospital, as the court may deem necessary as a result of defense counsel actions. Hey, Judge, what we'd really like you to do is we'd like you to send the referral to the bar, because that would be best, and that is true, right? If you can actually get the judge to send the referral to the bar, that will carry a little extra gravitas. Maya's lawyers can, of course, do it themselves, but, you know, lawyers sometimes complain against other lawyers, sometimes without cause, if we're quite honest about it. Sometimes lawyers use bar referrals as just an unlike button or a dislike button, rather than using it for its proper course. So the bar is somewhat, as a general rule, somewhat jaded, especially when you have an attorney in the case. It's like just another thing to poke the other side with. So if we can get the judge to do it, that would probably go a long way. So let us see what we have to support this proposition that the court should take action by sending this to the bar for further referral. The plaintiff's counsel is obligated to report defense counsel's trial misconduct to the appropriate authority. That is true. That is what the rules of ethics say. The appropriate professional authority for the counsel's report is the court as the presiding trial court. Sure, you could just make a direct referral to the bar, but sure, why not? Plaintiff's counsel is hereby making such a report by bringing the motion. The appropriate professional authority for this court to report the conduct to is the Florida Bar. These reporting obligations are mandatory. The rule saying a lawyer who knows of another lawyer who has committed a violation of the rules must inform the appropriate professional authority. Okay. Prior to bringing this motion, plaintiff's counsel has reviewed the trial testimony, arguments, and trial exhibits, including defense counsel's admission that material evidence concerning Johns Hopkins All Children's Hospital accreditation status and federal, state, and accreditation agency scrutiny concerning JHATCH's patient safety, risk management, and cultural failures was withheld from the defense expert on hospital administration, resulting in the elicitation of materially false testimony. I don't know. I mean, that's... Maybe. I mean, that is true, I suppose. I really hadn't thought about that way, but it is your expert, and if you fail to provide them the evidence necessary to give testimony, then you could be viewed as potentially suborning perjury. So yeah, that's one way of looking at it. Fair. Plaintiff's counsel has also interviewed witnesses to defense counsel's disparagement of jurors, breach, and related comments prior to bringing this motion. As determined under the Florida Bars of Rules of Professional Conduct, the undersigned is left with no choice without committing an infraction themselves, because they are obligated to do it if there is sufficient cause. So technically speaking, right, if there is cause to report it, you are technically obligated to report it yourself. So fair enough. Plaintiff's counsel is bound to bring to the attention of the court the actions of the defense involving direct and knowing misrepresentations of material facts. You can't do that. You have to have candor to the tribunal. The issue of Johns Hopkins All Children's Hospital status with the federal government and with reviewing organization, the Joint Commission responsible for reviewing hospital operations and quality of patient care, was at the core of the defense. I mean, yeah. The scheme to bolster the reputation of defendant and create a false impression that its organizations and actional culture had already been reviewed by authorities with the most power to consider its structure and patient safety record, and that JHATCH's management, including risk management and patient safety, were above reproach. That did seem to be somewhat not correct based on, the immediate jeopardy thing. Defense counsel fostered this false impression through a 9-week trial, first arguing to exclude the testimony of plaintiff's hospital management expert, to the contrary, based on Centers for Medicare and Medicaid Services finding of immediate jeopardy and public reporting of the same, and then eliciting false testimony from defendants' hospital management expert to the effect the hospital was and always is in good standing with the federal government, through CMS and with the Florida agency and the Joint Commission. Yeah. After maintaining the posture before the court and the jury through the elicitation of false testimony and direct misrepresentation of material fact, and after a ream of documents were discovered in defense counsel's possession that proved the contrary, defense counsels reluctantly admitted, under questioning by the court, the documents reflecting the true status of organizational culture and patient safety record withheld from the defense and never disclosed to the plaintiff. They do seem to have a problem turning documents over, but this is at least partially, in my view, and perhaps even dominantly, in my view, as much a fault of the court itself as JHATCH, because the court, including all 3 judges who oversaw this case, apparently lost the whacking stick. The whacking stick is a great thing, my friend. It is how you control the children. And as you have seen through this case, sometimes the attorneys do behave like children. And sometimes, like children, they deserve correction. Sometimes including the whacking stick. But the court seemed to have lost its whacking stick because it never seemed to punish JHATCH, despite its open, repeated refusal of JHATCH to obey the court's orders, such as turn over the report about the immediate jeopardy thing. And they're just like, no, we're not going to do that. We're just not going to do it. What are you going to do about it? Apparently the answer is not much. So there's that. So I blame you, court. I blame you for this. You and your predecessors. You didn't get J. Hatch under control. You never reprimanded them, and so like unreprimanded children, they pushed it further and further and further and further because there was nothing stopping them. And then you ultimately got to the end where they're behaving like the worst petulant children ever because they weren't whacked with the whacking stick. The court confronted defense counsel over the withholding of material information, which at this point, by the way, is a little late in the day. Just saying. Could have done that years ago, but all right. From defense expert and the elicitation of false testimony resulting from defense counsel's actions and questioning. Here is what the court said. The court, let me ask you this, let me cut you off. Did you even provide witness Mr. Anderson with any of the information we're discussing since Wednesday afternoon? Mr. Hunter, yes, sir, we sent. The court, he was provided the information because we had an issue with what was produced to Mr. Anderson. Witness Mr. Anderson. So I want you to be very clear about what specifically was produced to Mr. Anderson. Very, very specifically. Mr. Hunter, since Wednesday, he was sent the certificates. The court, I don't care what happened since Wednesday. At the time he testified to the jury, had the defense even provided any of the information we've been discussing since Wednesday? Mr. Hunter, may I ask Mr. Shapiro to address that? The court, Mr. Shapiro, do you want to step into the breach here? Mr. Shapiro, well, only to the extent he was provided hospital policies and procedure. Yes, sir, the court, that doesn't answer my question. Preach. Mr. Shapiro, I did not provide him joint commission surveys, no. So I don't know if he looked at anything online, but to my knowledge, no. So my understanding of his test, well, just to explain, my understanding of his testimony, Your Honor, is the fact that the hospital was being operated at the time meant they had gone through the joint accreditation surveys. That was simply basis of the statement he had volunteered. The court didn't even provide the information. Okay, what's next, Mr. Hunter? Breach. So you tried, it looks suspiciously like you tried to deceive the court by failing to provide your own expert the information from which to testify. So you got him to essentially perjure himself, although he didn't know it, because you lied to him through admission. And you know, that's not great. That's a problem. What became clear if the defendant was compelled to produce the document it had withheld was that J. Hatch had been placed in immediate jeopardy for patient safety and risk management failures, and that CMS, AHCA, and the Joint Commission had each made findings regarding failures. Well, GOG, that sounds like that could potentially be a problem. I mean, you know, CMS, AHCH, and the Joint Commission all make findings that all is not right in the state of Johns Hopkins All Children's Hospital. All's not right in Denmark. Boy, oh boy, maybe that's information that would be helpful to the fact finder to consider as they're trying to assess whether or not Johns Hopkins did a bad. I mean, of course, the fact finder is under no particular obligation to take the opinion of CMS, AHCH, and the Joint Commission as gospel, and the jury, of course, can say, you know what, we don't care what they think. All those people, we think Johns Hopkins did no wrong. CMS, we have no idea what you're talking about. But you know what would be really great? If you provided the information to the fact finder so that they could make the assessment for themselves. Further, the concealed documents clearly show that J. Hatch's senior management recognized the cultural failures, which, you know, is pretty obvious because the immediate jeopardy said, literally, your culture sucks balls. I think that's a direct quote. I mean, it's been a while since I read it, but I think the immediate jeopardy said, your culture sucks balls. I think that's a verbatim. And took deliberate steps to counter J. Hatch's culture of fear and retribution that exacted swift punishment on hospital employees who spoke off on behalf of patients who had been harmed at J. Hatch. There's a sound problem? Please tell me there's not a problem with my sound. Is everything okay with my microphone? Do we have to have microphone issue again? Sound is good? Okay. J Hatch's corporate representative, thank you. J Hatch's corporate representative, Angela Green, testified that the cultural failure spanning at least 5 years back from the immediate jeopardy findings, including the time span of Maya Kowalski's admission, and that J Hatch's interim CEO had independently validated the reports of retaliation and retribution directed at good faith actors within the organization. Yeah. By misleading the jury and the court about defendants' accreditation status and compliance with patient safety mandates, and by sanitizing the information given to its expert witness and then eliciting false testimony through the same expert, defense counsel was in clear violation of the rules. A lawyer shall not assert or controvert an issue therein unless there's a basis in law and fact for doing so. A lawyer shall not make a false statement of fact or law to the tribunal, or fail to correct a false statement of material fact or law previous made, offer evidence the lawyer knows to be false. A lawyer shall not engage in conduct involving dishonesty, deceit, or misrepresentation. Well, boy, oh boy, I mean, some of the things J Hatch did seem to potentially implicate some of these rules. Some of these rules seem problematic to me. Maybe it's just me. Thank you, Anne Ramushin, for being a member for 10 months. We do appreciate everyone who supports the channel financially by being a member, by hitting that beautiful, beautiful join button. We appreciate it. A second basis involves the statements of dishonesty the defense counsel made, disparaging jurors and the Kowalski family upon rendition of the verdict, as well as the public statements of defense counsel further disparaging the jurors. Thank you, Anne Ramusin, for the 10 gift memberships, and thank you, Robin, for being a member for 7 months. Upon rendition of the verdicts, as well as the public comments of defense counsel further disparaging the juror and the courts in the days and weeks following the verdict, defense counsel referred to the Kowalski and these outbursts as scumbags, and the jury as 6 people from the bus stop, which we've already commented on somewhat extensively. I have many, many problems with this phraseology. Thank you, Nancy D, for being a member for 2 months, and thank you, Not Cupcake S, for joining as an uncivilian. We do appreciate you joining the party. It is a beautiful thing. And then 2 months after the verdict, defense counsel disparaged the court through local media as well, which isn't great. Thank you, Nikki Lewis, for being a member for 12 months. We appreciate that. Thank you for joining and for continuing your support. Tampa Bay Times saying, despite Tuesday's ruling, Ethan Shapiro, co-counsel for All Children's, said the hospital still plans to appeal the court's decision for as long as necessary. Well, you don't have a lot of steps. I mean, you've got exactly 2, so good luck. He said the court failed to grasp the complex medical, child safety, and legal issues in the case. So the jury made a mistake? Any fair and unbiased review of the facts and the law in the case completely vindicates the care provided by the experts at Johns Hopkins. I mean, I don't know. I had my doubts, to be fair. I didn't come in as a hypercritic of Johns Hopkins, to be sure. I had even doubts even after the jury came back about some of the jury's findings. I was like, I don't know if it's supportable. And then, we had a discussion about it, and it's like, yeah, no, it's supportable. So, I think there is sufficient evidence for the jury to reach these conclusions. Shapiro said it's a sad indictment of the judicial process in the case. The facts were concealed and laws misrepresented to the jury. Mr. Shapiro. Okay, look, I'm sorry, dude. We got to have a talk, you and me. You cannot go to the press and complain about facts being concealed and misrepresentations made to the jury when you and your team and the attorneys representing Johns Hopkins All Children's Hospital defied court orders by failing to produce evidence that you were under obligation to present repeatedly, and then failed to provide your own expert with the information sufficient to provide a full picture to the jury. You didn't want that part of the picture to be presented. I mean, I understand that you didn't want that information to be presented to the jury. I really wouldn't want that information to be presented either. I totally understand. If I were representing Johns Hopkins, I'd certainly be doing everything I can think of to not have it represented. But, I still respect court orders at the end of the day because I'm a good attorney. You see, that's the thing, right? I'm a good attorney. I will zealously represent my client. I'll represent Johns Hopkins. I will do my absolute best. But, when the court makes a decision, I'm going to, follow it. I might try to protest it some more, but I'm not going to be in open defiance, Ethan. You behaved badly, sir. You behaved badly. Johns Hopkins deserves competent representation. I have no problem with Johns Hopkins All Children's Hospital giving every possible defense to them available at law. I don't even have a problem with Johns Hopkins and their lawyers trying to present the case from the evidence that's available that they did right by Maya. That's totally fine. That's what they're supposed to do. The short definition of what a lawyer is supposed to do is amplify good evidence and try to diminish or minimize bad evidence. That's the whole thing, right? I'm going to try to shade the evidence as best as I can to present the best case for my client. And those parts that are, not so great for my client, I'm going to try to diminish or minimize or try to explain away in some way. That's my job. But what I can't do is not give information to the other side. See, we have to show each other our cards. That's the thing. So you can get up there and say Johns Hopkins did no wrong, but what you can't do is refuse to do disclosures, refuse court orders, obstruct the process, materially misrepresent things to the court by up to and including failing to inform your own expert, so you're eliciting false or at least incomplete testimony. There are ethics, man. There are ethics. There are rules to this. Thank you, Lady D12, for gifting 5 gift memberships. It is appreciated. Thank you very much. And thank you, Kim Salva, for being a member for 15 months. I appreciate you being here. Defense counsel's public statements disparaging the court and jurors, coupled with defense counsel's loud, profane outbursts while exiting the courtroom, I'll give them a pass for that. I mean, among their many sins, it's not great, but among their many sins, I'll give them a pass for, their comments as they left the courtroom out of frustration. In the long list of things to, say Johns Hopkins did wrong, I'll give them a pass. We all been there. We've all been frustrated. We've all said something, perhaps we shouldn't. We can forgive you some sins. A lawyer shall not engage in conduct that is prejudicial to the administrative justice, including knowingly disparaging, humiliating litigants, jurors, witness, court personnel, or other lawyers. See, again, I will give you a pass for your off the cuff, frustrated comments as you're leaving the courtroom and people overhear you in the hall. I'll give you a pass. What I won't give you a pass for is your deliberate, intentional, repeated, doubled and tripled down haranguing of juror number 1 in every possible way, including the secret Nazi symbols. See, that's the thing that reflects deliberate intention, as opposed to a flip remark that escapes one's mouth. So yeah, that's the thing. The Florida Supreme Court interest in ensuring the judicial referrals to the Florida bar are resolved correctly is demonstrated by the Supreme Court's October rule change, which now requires any referral to the bar that does not result in a finding of probable cause or the filing of formal complaints to be submitted for review and approval by the Supreme Court. The bar will submit to the board's recommendation for approval of judicial referrals to the clerk of Supreme Court as soon as practicable after the board's decision. Referral these matters to the Florida bar also makes practical sense. The court has neither time nor resources to do the review, of the serious matters to arrive at a result that is the correct result for lawyers. The Florida bar has the resources. Yeah, fair enough. This is not really the judge's province with respect to the sanctions that the bar might deal out, but of course the judge does have inherent authority to deal with the misconduct that occurred in his courtroom. Once again, the whacking stick should have been deployed much, much earlier. Because at this point, what's the point? The whole point, one of the points of the whacking stick is to correct you so that perhaps you'll sin less. The same reason we punish people, right? The same reason that we punish people more as they do more crimes, right? We'll give you kind of a break for the first crime you do, because we're kind of hoping that maybe you'll learn your lesson and not do crimes anymore. And then as you do more crimes, we're like, okay, the first lesson didn't work. We're going to escalate a little bit. And then as you do more crimes, okay, you didn't learn, so we're going to escalate a little bit, right? So the whacking stick is also part of the criminal justice philosophy at large. Also really good for the judge in the case. You start small, you show that you have the whacking stick and you're willing to use it. And most of the time, the attorneys comply because they realize that you're serious and they know where the whacking stick ends up. Right up their asshole. So they don't want it that way. So they're going to do their job. So that would be great. Okay. So we turn our attention now to the plaintiff's motion for attorney's fees and costs. We would like money for the fees because, of the bad things that you do. All right. Plaintiff, through their undersigned counsel, moves for the following. Plaintiff's counsel were first contacted by plaintiffs on or about 2017, just 30 days after Maya's discharge. Plaintiff's counsel firm was formally retained about a month later, at which time plaintiff's counsel investigated the case and prepared for initiated notice to defendant as required by law. Following several extensions of the period, the pre-suit period, which were granted by plaintiffs to defendant in order to facilitate a thorough pre-suit investigation. So, in this context, apparently, they are required to give some kind of notice before they sue. It's a Florida-specific thing, whatever, okay? They have to give notice before they sue. Cool. So they did that, and then there was extensions of the period. After investigation, defendants rejected the claim, which of course is no surprise. Following defendants' rejection of the claim and the failure to make any settlement offer, we filed a complaint. The complaint was amended on several occasions, too many to be honest, including the plaintiff's sixth amended complaint, which also sounds like a lot by the way, which asserted punitive damages, even then over 3 years into the litigation with punitive damages at issue, following the second DCA per cur denial of defendant's interlocutory appeal. Yeah, we've already been to appellate court and back before. Johns Hopkins made no settlement offers. Ultimately, the case went to trial on plaintiff's 8th amended complaint. That sounds like just too many. That sounds like too many too, to be quite honest. You get one amended complaint as a matter of right, typically. And so like anything more than two, and it's like, why are we doing this? So maybe the whacking stick should have also came Maya's way. Maybe there's just a lack of control all around. Maybe Johns Hopkins was enabled by the lack of the whacking stick against plaintiffs. I don't know, but it seems like there was no whacking stick to be found anywhere. Ultimately, the case went to trial. Ahead of the trial, J. Hatch made a nominal settlement totaling $1.6 million. I mean, I don't know if I'd go so far as to call that nominal, to be quite fair. $1.6 million is a pretty healthy settlement. Now, it's not that much compared to the ultimate sanction, but $1.6 million is actually, it's not like the most unreasonable thing I've ever heard of in my life. I wouldn't go so far as to call $1.6 million nominal. That's a pretty healthy offer. So I don't know if I go that far, but okay. It wasn't $50,000, $1.6 million is, a lot. Particularly because, of course, as we've discussed, the cause of action relating to the death of Maya's mother, at least in my view, continues to be an issue that is challengeable under law. right? We've half the damages the jury awarded basically were due to the death of Maya's mother, which I have questions for as a matter of law. I'm not sure that's legally sustainable. So I feel like that's going to go to the Florida Supreme Court case. So if you ignore those damages, which is a reasonable thing to ignore, as you're calculating a settlement offer, it's like $1.6 million to settle the rest of it. You know, $1.6 million buys a lot of physical therapy, emotional therapy. Not the worst idea I've ever heard of, but okay. Yeah. The trial began on September the 11th and continued for 9 weeks through November the 9th. Not considering attorney's fees over 7 years, I would be amazed if there were any attorney's fees, because I'm sure this was a contingency case. So you'd have to pay the lawyers presumably 40%. So, but that's typically true. So, but still. I mean, that's part of the deal, right? When you go to contingency, because you pay them on the back end. So, yeah. $1 million isn't. They were forced to do litigation over 6 years. Yeah, as the judge himself reminded the jury in the jury instructions, you cannot use the stress of the litigation itself as part of the damage calculation. That is not correct. You cannot use the length, stress of the lawsuit itself as part of the damages. So that is not a correct factor to factor into this equation. So it won't even cover some of the attorney's fees. Again, I would be amazed if their agreement was anything other than contingency. So I would imagine it would pay the attorney's fees. I haven't seen the retainer, but I imagine it would pay the attorney's fees. And it's up to them to decide whether to settle. I think her lawyer mortgaged his home to continue. Well, that's on him. That's on him. It's irrelevant. Again, I don't know how I can explain this any clearer. The judge himself told you. It's not just me. Go listen back to what the judge told the jury as he was giving the jury instructions. The judge himself told you. You cannot factor the strength or difficulty or stress or whatever of the litigation itself as part of the damages. It's irrelevant. It doesn't matter. You can't use it. It doesn't matter. So whether or not the lawyers mortgaged his house is irrelevant. Whether Maya suffered as a result of the litigation is irrelevant. It doesn't matter. You can't use it as a factor. Yeah, testy? I'm not testy. I'm just telling you directly. I'm not testy. I'm just telling you emphatically. This isn't testy. This is me being direct. You can't do it. You keep trying to do something you're not allowed to do. I'm like, you can't do this. Yeah. And the jury wasn't deciding attorney's fees either. Yes. Yeah. But this is us saying why settlement is far less than what the jury decided. But the settlement also is related to the same thing, because the settlement is for the injury. That's what the settlement is. The settlement is for the injury. Right? Because Maya suffered in the whole thesis of this thing is that Maya suffered injury, and Jack and the other and his son. The three of them suffered injury, and the mother, that the four of them suffered injury as a result of J. Hatch's action. That's the cause of action. The settlement is for the injury that occurred. That's the thing. That's the case. The settlement is for that. What you're trying to do right now is you're factoring in things that are not the thing. The settlement is related to the thing, and you're factoring in things that are not the thing. So you're saying that's why the settlement's improper, but that's wrong. You can't make that argument. It's wrong. Yeah. That's wrong. You can use it. You're just not allowed to because the U.S. system sucks. All right. Look, guys, we have a system of law. All right, there's law. We have rules. My entire condemnation of J-Hatch as it relates to this case is because they didn't follow the law. There are ethics rules. There are rules. They didn't follow the rules. Okay? I'm mad at them because they didn't follow the rules. Now you guys are saying, I don't want to follow the rules. I'm going to be mad at you because you're not following the rules. There are rules. You're not following the rules. J-Hatch isn't allowed to not follow the rules. You're not allowed to not follow the rules. You have to follow the rules. There's nothing wrong with the U.S. system. The U.S. system is fine. And this is the rule. This is the law. So let's stick to the right legal analysis. 1.5 blows the settlement for 3 victims? Well, maybe, but then you have to calculate out what is a reasonable cause of action for their damages. So what are you trying to pay for exactly? You're trying to pay for Maya. And what else are you really trying to pay for here? You're trying to pay for, because the son's causes of actions are all based on the mother's death. So we don't know that. So when we're talking about settlement, we don't know that that's a valid cause of action. Maya's father's damages are all related to his wife's death, like loss of consortium, that kind of thing, right? So if the mother's death is not a valid cause of action, then the father has no damages. The son has no damages because all their damages emerge from that. The only thing left is Maya's mother's damages while she was still alive, and those amounts from the jury were fairly nominal, as I remember. So, like, yeah, yeah. Dads are for infringement of his rights as a parent. There's a little bit of that too. That's fair. That's fair. Yeah, that's fair. All right, let's move on. I just want you guys to follow the law, right? This is where I get a little bit irritated, right? Because this is sometimes where I get irritated with the chat, because, like, look, the law has to be applied neutrally, and you guys like the law when it favors you, right? You guys like the law when it does what you want it to do, and I appreciate that. You guys like the law doing the thing you like it to do, but when it doesn't go your way, you can't, like, you gotta kind of have your cake and eat it too, man. It's like, dude, right? You can't, point your finger at J-Hatch and be like, look at them, they're breaking the law, and then be all pissed when I'm like, you guys are also not following the rules. Like, you gotta be equal here, man. So when I give you a legal analysis and I'm like, look, this is not the right analysis, it's like you guys fight me because you don't like the conclusion. And it's like, that makes me a little sad sometimes. Yeah. So it makes me a little sad sometimes because, like, that's the wrong way to think about this. Yeah, you can't be in favor of the law only when agreeing with the outcome, right? Yeah, that's the thing, right? The law has to be applied neutrally. J-Hatch is entitled to every benefit of the law too. J-Hatch is entitled to every benefit of the law too. That's the thing. That's the whole thing where that's the thing, right? Maya is no better, nor is she any worse than Johns Hopkins in the first instance. They are equal justice under law. They're both entitled to the protection of the law. And, so that's a good thing. Defendant filed a motion for remittere, which is a reduction, and the court reduced the jury's award to Jack Kowalski as a personal representative of the estate. On January 19th, the court filed judgment in the following amounts. Maya Kowalski, $140 million. Jack Kowalski, $1.5 million. Jack Kowalski, as the personal representative of the estate, $66 million. You're forgetting that the lawyer and Kowalski both sold houses to finance their lawsuit. No, I'm not. I am not forgetting that. I am not forgetting that. It's irrelevant. Great. In the final judgment, the court reserved jurisdiction to award attorney's fees or costs or both upon a timely or successful motion. Plaintiffs now bring to the court's attention several independent bases on which the plaintiff requests the Honorable Court award fees and costs. The court's inherent power to award fees and costs pursuant to Chapters 57 of the Florida statutes, the defendant's rejection of plaintiff's proposed settlement under the Florida statutes, and defendant's failure to admit the truth of the matter is requested in the request of the remissions and award of reasonable expenses and attorney's fees. Expenses must be considered? Nope. No, I really don't. No, they don't. The jury would be in error to consider it. The jury was never provided information about the expenses of the lawsuit, nor would they be. It would be improper for the jury to consider it. No, expenses really do not have to be considered. The expenses are irrelevant. Johns Hopkins can only be held responsible for what they did, period. Johns Hopkins, this is really simple, guys. This is very, very simple. Johns Hopkins can only be held responsible for what they did. Okay? Whatever they did stopped the moment that Maya left the hospital. Right? I mean, they didn't do anything to her after that, did they? I mean, that's right. That's when Johns Hopkins stopped doing things to her, when she left the hospital, right? So everything after that isn't something that Johns Hopkins did. So the Kowalskis selling their home is irrelevant. The lawyers selling their home is irrelevant. The expenses of the litigation are irrelevant. They are not things that Johns Hopkins did. Plaintiffs are entitled to recover costs as a prevailing party pursuant to law in accordance with the statewide uniform guidelines for taxation costs in civil actions. The guidelines provide for the taxation costs is within the broad discretion of the trial court, and the court has relevant reserved jurisdiction for the purpose. J. Hatch Building has a lien against their hat. Well, see, I think that's improper. If J. Hatch has a bill, yeah, I know J. Hatch has a lien against them, but that lien is improper. So that's something J. Hatch did. There you go. Yeah, they shouldn't have done that. But, you know, that's part of the jury's so you can calculate that. I mean, that the lien was for the medical expenses, right? So the $1.6 million would pay off some of those expenses. So, I mean, you know, I don't know. And maybe it's not enough, but it doesn't. I mean, also incidentally, by the way, I never said it was enough. I think maybe you're overreading what I said. I simply said, I simply questioned their word choice if we want to be precise about what exactly I said. They called it nominal. My only argument was I don't think it's nominal. That's really all I said, is I don't think it's nominal. I never said it was enough. I never said it was something they should accept. I said it seemed like a potentially reasonable calculation in something that made sense. My only real criticism was with the word choice nominal. This entire diversion between me and you has been based on my criticism of the word nominal. That's how this train went off tracks. Relatively speaking, it's nominal. Well, you see, you don't know that at the time. That's the problem, because it's only nominal in retrospect, but you don't know that at the time, because you can only know things when you know them, right? It seems nominal now. I guess it seems nominal now, but of course, if you're considering the settlement, you don't know what the jury is going to do or not. So you don't know right? At the time they made the offer, is it nominal? Because at the time they made the offer, the jury hadn't reached its decision yet. In fact, the trial hadn't even started yet. So is it nominal at that point? Given what you knew then, is it nominal? I don't know, man. I mean, it doesn't strike me as nominal. I mean, you know, given the available information at the time, it doesn't strike me as inherently nominal. So I'll tell you. Yes, based on fees, I'm going to kill you guys. I'm going to kill you all. I'm going to stop talking about this. All right, where were we? Plaintiffs are entitled to recover costs of the prevailing party in accordance with the statewide uniform guidelines for taxation of costs in civil actions. The guidelines provide for the taxation of costs is within the broad discretion of the trial court, and the court has reserved jurisdiction for this purpose. The plaintiffs had calculated the cost incurred in this action is in accordance with the guidelines and a tabulation. Plaintiffs have included that litigation costs should be taxed as described in Section 1. Weird with the capitalization here for some reason. And litigation costs that may be taxed is described in Section 2. If plaintiff have made all efforts to remove costs that should not be taxed as costs of Section 3. In addition, plaintiffs pray the court grant attorney's fee for the bad faith litigation and tactics of the defense under the inherent authority of the court to assess fees. A trial judge has inherent power to award attorney's fees for bad faith conduct as a sanction against offending party, even in the absence of authority. Fair enough, and if the judge wants to award some attorney's fees for the bad faith of the other side, I'm here for it. The defendant constructed a multi-year scheme to cover up the hospital's systematic and cultural failures and attempt to mislead the jury and the court that the hospital continuously met federal regulatory and accreditation requirements. Plaintiff raised these risk management and patient safety failings as early as March 14th of 2020. Defendant engaged in contemptuous conduct, leading the court to contemptuous conduct. Is that really how that word is spelled? No, it's contumacious. Contumacious conduct. I don't know what that word means. Hold on. I have to look it up. Contumacious. Contumacious. Stubbornly disobedient, rebellious. Stubbornly or willfully disobedient to authority. Okay, interesting word. Defendant engaged in contumacious conduct, leading the court to believe that the issues were simply media fodder and confined to pediatric heart surgery. Well, they simply tried to do that. Going so far as to withhold the CMS findings and accreditation review from their own expert. Defendant's bad faith conduct was discovered and outed during the trial. Nice. But such conduct should not go unpunished and must be discouraged in the strongest possible manner. Defendant's bad faith conduct did not stop with the verdict, however. Defendant engaged in a rabid and unhinged attempt to destroy juror number 1. Preach. Preach. Yeah, I can get behind this. I can get behind this hardcore. Yeah, what they did to juror number 1 is loathsome. It's like, you know, of the many, I mean, I got into this late, so my assessment of the evil of J. Hatch and their lawyers is latently biased, or is it's biased by lateness in time. The later things happened, I'm more offended by it because I got into this late. So I am personally offended the most. I think I can say that. Yeah, I think I might be the most offended by what they did to juror number 1. Partially because I, as a lawyer, just expect more from my profession. You know, I'm not a doctor, so I'm not offended on a professional level by J. Hatch, but I am a lawyer. So I'm not only personally offended, I'm professionally offended. And so it kind of pisses me off. Plus, it makes me look bad, and I don't like it very much. So it might be the thing that pisses me off the most, what they did to juror number 1. Employing an army of faceless and nameless Reddit users, hey, Reddit users, go fuck yourselves, to investigate juror number 1 as immediate family. In doing so, the defendant alleged that juror number 1 employed neo-Nazi symbolism. They sure did say that. And repeatedly made false statements to the court. Pointedly, defense counsel stated as a fact that Deborah Salisbury, former counsel for the plaintiffs, had represented juror number 1's current wife in the divorce proceedings. Defendant made that claim with reckless disregard for the truth. Preach. Yeah, you're a doctor and professionally offended by J. Hatch. See, that's the thing, right? You're going to be professionally offended by J. Hatch and the doctors, and I'm going to be offended by their attorneys. I imagine there's a lot of medical professionals who are not super duper thrilled with some of the things the doctors and or nurses at J. Hatch did. I'm just speculating, but I think some of the medical community may also be somewhat offended by some of the things that occurred. Some questionable choices, perhaps, that some of the medical community might be looking at, be like, I think that kind of makes me look bad, and I'm not super happy about it. And I can definitely see that. Defendant made the claim with reckless disregard for truth and a bad faith attempt to influence the court's view on the verdict and the alleged prejudice of the jury. Defendant has never corrected the false statement. Defendant's actions have brought discredit on the judicial system and the bar. Preach, preach. I personally really hope, it's a lot, but I hope for a public reprimand. I won't get it, but I kind of want it. I really want them to be brought down into the well of the Florida Supreme Court and publicly shamed. It would make me feel a lot better personally. Plaintiffs severed proposals for settlement on defendant J. Hatch on the following dates of the following amounts. Okay, so here are some amounts that they propose. Plaintiffs served proposals for settlement on defendant J. Hatch on the following dates. J. Hatch on February the 18th, 2022, $2.5 million. Jack Kowalski, J. Hatch on 2023, $5 million. Jack Kowalski is PR of the estate to J. Hatch on July 28th for $10 million. I have to say, guys, once again, I don't think 1.6 million can really be said to be nominal in light of these amounts. It might be a low ball, but I don't think I'd go so far as to say nominal. Because they were talking about, what were they talking about? 2023 when they said it? Because they said, hold on. They talked about the jury trial on January 24th, 2023, ahead of the trial. So they don't make specifically clear when ahead of the trial that J. Hatch made this offer. So let's assume it's 2023 though, because that's the frame that they mention. And then apparently in July of 2023, Jack Kowalski said 5 million. So again, I don't think you can say 1.6 million is nominal in light of apparently a settlement offer of about 5 million. So does anyone in chat want to take back their argument with me now? Anyone want to take back their argument with me now? That it wasn't nominal. It's nominal. I can't win with you guys, I swear to God. Man. By virtue of the verdict as resulting difference, the plaintiffs arguably prevailed on Jack Kowalski's proposal and overwhelmingly prevailed on Jack Kowalski's proposal on behalf of the estate. Thus, plaintiffs are entitled to fees from the day the proposals were served, arguably as early as February 18, 2022, but without a doubt from July 2023 onwards. Pursuant to White versus Steak, an ale, cool name, in order to compute the judgment obtained for the purposes of entitlement fee, the trial court must add to the net judgment all taxable costs incurred by plaintiff prior to the day of settlement was served, and in addition, where applicable, the plaintiff's attorney fees up to the day of the offer. Plaintiffs are entitled to recover from defendants reasonable costs and attorney's fees since judgment obtained is at least 25% greater than the proposal Jack Kowalski served. To trigger this recovery, plaintiffs was required to obtain judgment of at least $12 million or judgment in the amount of at least 25% greater than the offer of $10 million. The court entered final judgment in the amount of $66 million, more than 6 times the proposal. Since plaintiffs exceeded the threshold, plaintiffs are entitled to sanctions. Okay. Why don't I feel like a public reprimand could happen? It's a lot. It's a lot. I would truly be amazed if they get as much as a private reprimand. I really would. I know that that's disappointing, but I just have to be honest with you. I mean, their tactics are scummy, and their tactics are not good, but typically the bar tends to look, well, let's do it this way. They didn't F the client. They didn't F with the client's money. So they didn't violate their client's privilege. So they didn't do any of the big sins. And there are arguably attorneys that are worse. I'd be pleasantly surprised if you got as much as a private reprimand, to be honest. My expectations here are pretty low. I am. I'm yeah. But hey, surprise me, Florida Supreme Court. Surprise me. The Florida rules provide that if a party fails to admit to the genuineness of any document or the truth of the matter requested under the rule, and if the party requesting admission thereafter proves the genuineness of the document or truth of the matter, the requesting party may file a motion for an order requiring the other party to pay for the requesting party. By the way, just out of nothing, I changed the background lights on my thing. I put in the more powerful LEDs, and I changed the background to a more pleasing teal. I think I have the remote here. We can play with the remote for a second. Let's see. So we got blue. That's just blue. That's pretty cool. And then we got purple. And we got this. That's like a more, this is technically purple. And then we got this one, which shows more purple on screen. That's pretty cool. And then we got this one, which is more of a brighter teal. And then we got this one, which is slightly paler. That's pretty cool. We got red. If we want to go, we can do like Emily D. Baker. We could do like Emily D. Baker and do different colors for different levels of fuckery. There's all kinds of potential. Green. We got orange. Hey, orange is pretty good. Orange is pretty good. I have to say, I like kind of orange. Peach. That's kind of cool. All right, let's go back to light blue. All right, yeah, so cool. Yeah, I think teal's a winner. On issue after issue, plaintiff provided to trial the court the truth of the matter that J. Hatch failed to admit. The pivotal request for admission in J. Hatch unsupported and proved disingenuous denials had been set out in the notice of outstanding sanction requests and motion for sanctions pursuant to rule. Yeah, see, with the mic and shirt, you like the teal. See, that's the idea, right? So, yeah, you get that nice little orange contrast because you get the orange-blue contrast, right? So I wear the blue shirt with the blue background, a little orange-blue contrast. Yeah, these are things we think about as we think about color theory in you. The matters for which admissions were sought in plaintiff's request for admission dated October of 2022 and defendant's request thereto on November of 2020, or October 2020, defendant's response in November 2020 demonstrates plaintiff's entitlement. Defendant denied that Dr. Sally Smith, a hero to the cause if there ever was one, was a residency rotation director, a matter clearly proven by documentary evidence at trial. J. Hatch denied the same in response that it had received citation or warning from a state or federal agency for failing to disclose an adverse event between 2015 and 2017. Another matter clearly proven for J. Hatch's late production of documents related to the imminent jeopardy. J. Hatch's late production of documents related to the imminent jeopardy classification on the hospital. Similarly, J. Hatch denied it did not track, trend, or analyze objective data to monitor the overall quality of care and or patient safety provided by the hospital. This is almost verbatim recitation of deficiencies noted by C. Hatch and J. Hatch itself in their reviews of the hospital and failings of quality and safety outcomes. In request for response to admission, J. Hatch continued to fail to admit critical matters in this lawsuit. Defendant's response to the plaintiff's request for admission filed of April 2023 contained other numerous failures to admit warranting the award of attorney's fees and costs. Among the issues disingenuously denied in defendant's April response, J. Hatch denied that knew Maya Kowalski receiving ketamine infusions to treat her CPS. No later than December 1st, 2015, a matter demonstrably proved true by J. Hatch's medical records. J. Hatch initially denied it never objected to the use of ketamine to treat Maya Kowalski prior to 2016, and again, no proof supporting that denial was offered at trial. J. Hatch's denial include outright denials of absence of entries in Maya Kowalski's medical records, and egregiously, J. Hatch denied that Catherine Betty took photographs of Maya Kowalski in January at the direction of risk management. Miss Betty herself testified to that irrefutable fact. Plaintiffs are entitled to attorney's fees and reasonable expenses for having proved these matters at trial. I don't know, maybe, but the sanctions one is looking more promising to me. Conclusion, plaintiffs are entitled to costs and attorney's fees based on 3 independent bases. Plaintiffs respectfully request the court proceed in a phased approach to entitlement and amount of costs and fees. Plaintiffs suggest that the first phase would be a hearing on entitlement in the hopes the court's rulings on plaintiffs' entitlement to costs and attorneys and fees will facilitate a more productive post-judgment mediation, which the parties have agreed will occur in April. So that we hope that we'll have discussion so it can influence our mediation. Cute. The light blue is cyan. Well, what's teal? Is teal blue plus... What's teal? Isn't teal green plus blue? Yeah. Isn't teal green plus blue? I'm confused. Yeah, so that's green plus blue. So that's teal. Yeah, teal is green and blue. Yeah. So that's... Yeah. So that's all green, then lighter green, then blue, more blue, even more blue. Yeah. Cyan is just blue or green plus blue? Yeah, well, yeah. So we're arguing over a very small distinction between cyan and blue. Great. Wherefore they pray that we'll get costs, and then there's some documentation relating to that. Exhibit A, and then they go through a whole bunch of things that they build, and I'm not going to read that in detail about all the things. Wow. Are these dollar amounts? I guess they are. Okay. $36,000 Ellen Francis MD invoices. $36,000 in other invoices. $33,000 Lynn Webster. I don't think you're going to get all this. I don't think you're going to get all this. Various process servers. $20,000 for trial trilogy consultants retainer regarding presentation of documents. $36,000 for Timothy Bouton's invoice. $199,887 for Trilogy Trial Consultants invoice regarding Dan Ray's technological support at trial. Damn. The IT guy gets $200,000 in damages? That's a lot, man. Jeez. This is good to be IT. Here's like proposal for settlement. Wow, this is very formal. This is very formal for a proposal for settlement. It's interesting how it's written up. Jack Kowalski hereby offers to settle any and all claims against defendant for a total payment of $10 million. Punitive damages are part of this claim, and $1,000 of the total proposed to settle the claim. Attorney's fees, it does not include attorney's fees that are not part of a legal claim. The proposal is accepted. They will not pursue any damages in the form of attorney's fees. The $10 million to completely settle the case on whenever this is signed. July the 28th of 2023. So $10 million to completely settle it, proposed by Jack in 2023. Interesting. And then proposal for settlement, and that's the end of that. Okay, great. So that brings us to the end of these streams. Yeah, that's cool. So they proposed $10 million to completely settle the case, and $5 million was offered at an earlier time. And if I read it correctly, $2.5 million at an even earlier time. Well, I bet Johns Hopkins wish they had taken that offer right about now. $2.5 million to sell this thing. Sounds pretty good. Trilogy Trial Consultants was much more than IT. Their jury consultants trial strategy well worth the money. I'll take your word for it, man. Take your word for it. My sound is fantastic. Thank you. I spent a lot of effort dialing my sound completely in, especially for when we do streams with court audio. We spend a lot of time making sure to get the audio dialed in. We spend a lot of time making sure to get the background moved in. For those of you who don't know, by the way, I moved to Houston, and we got the background dialed in to make it really cool. So it's kind of white. It's supposed to be peach. Comes off more purple. That's actually pretty cool. It comes off way more purple than it is in real life. Oh, that one's pretty good too. That's pretty good deep purple. Houston wife? Not yet, maybe later, ma'am. It could also tone it down a little. It can make it a little less bright. How am I liking Houston? So far, so good, man. So far, so good. I'm liking it a lot, man. So far, so good. I do have X followers. It's just from time to time, the X followers thing doesn't work. As you can see right now, it says the user does not exist. So sometimes it gets stuck. Can we get the lights to react to membership? Not these lights, no. Not these lights. These lights are just by a controller. So they're not smart lights. I had different lights. I had different lights from Govee that were smarter, but these ones I think are even brighter. They had a higher density LED in them. So, yeah. Pretty cool. I don't know what this button does. Let's find out. Okay, that's a thing. can do that. What did I do with the light strip? Oh, I still have it in case I want to change my mind. Oh, you mean what did I do with it? I just put it on the back. You see the metal bar. You see the metal thing. See the metal holding up the thing. I just ran it up and down the back of the bookcase, up and down the metal thing. So I ran it up. I ran it across the bookcase so that it was hidden. It's taped to the back of the bookcase. Yeah, so it's just taped to the back of the bookcase. No muss, no fuss. These are LED light strip. It's not strictly speaking a light bar. It's a light strip. They're LED light strips, so they're little thin strips, and they just go up and they go up each length of the bookcase, and then one of the bookcases goes over, and then down the length, and so forth and so on. Pretty easy. You like green? That's pretty cool. It matches my shirt though. It's a little much. I think I'll go with that one. I think that's good. Cool. All right, great. Yeah, I was a fan of the dark blue. Like this color? You like that dark blue color? Dark blue is cool too. You like dark blue? That's a pretty cool color too. Dark blue's not bad. Too saturated? Yeah, we could do a lighter version. Purple. Let's try this one. How about that one? That like lighter purple? Maybe something like that? Like a lighter purple? That's kind of cool. All right, guys, I'm going to sign off for now. Did anything happen to Smith for breach of confidentiality? I don't know. So, yeah. All right, we'll keep that one for the light. You like this one, Tony? Okay, I like this light too. It's kind of lighter purple. Yeah, I like it too. Do I want to send you to Rob? Okay. You know what? I'm not going to do it. I'll send you over to Legal Vices. He can use some love. Say hi to Legal Vices instead. He's streaming this issue. He's streaming about Maya, so I'll send you over to Legal Vices way. All right, guys. I will talk to you later. Until later, my friends, I hope you have a good day. Bye-bye for now.